public session now. I have my own agenda for what to cover today in the pretrial motion, and so I'm not sure what you have. I didn't receive any specific motions to cover today, other than I think the ones previously submitted by defense related to questioning of the jury. As I indicated, I don't intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages. And as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion. So starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want. And that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so I, particularly where I can't recall whether Ms. Massoth has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial for a couple of reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on an instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Herwood facilitated the defense viewing it yesterday.
Okay.
It is available for the court's inspection if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not an appropriate way for it to be described, given what occurred there and the victims.
I think a better term is simply a model,
Yes, sir.
rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Your Honor, we did. We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the 3rd floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence vault of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in as a demonstrative aid, I am curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find someplace not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Thank you, sir.
The other thing that I would point out, as it sounds like you've been, at least to some degree, working together, and I appreciate that. As you come to stipulations on agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is in the middle of, for example, trial, well, Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire, so that they don't just get a list of 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania, these are witnesses that work for the FBI, these, right? And so that they can put in context those names, which will be, result in a more accurate review by them of those names to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense had, we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. And I want some additional information there. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Your Honor, on June 18th, Ms. Massoth has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not, depending upon where we're at. That's my concern.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons. If we could avoid that date, if we can't, then I guess we can't.
Well, let's, can we start by like noon on the 18th?
12:30 or 1. I'm in federal court.
Right. Let's do 12:30. Are you handling those issues?
Alternate perpetrator. I'm, yes, very involved.
Let's do 12:30 on the 18th. All right, next I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So I won't ask you if you have questions now because I suspect it will fit into, if you do, a more specific category and we can address it at that point. But if you have a question or concern about anything we've talked about thus far, now's your chance.
I believe so, Your Honor.
No, Your Honor, thank
Right.
you.
All right, juror questionnaires. I'm trying to strike a balance between asking enough, but not asking too much. And so I think it strikes that balance. But if you have any concerns about what we are asking or what we are not asking, please provide those concerns, say like by Tuesday, Wednesday of next week. And then what I will do is if it appears there's enough flesh on the bone to merit a hearing, we can have that. Otherwise, I will simply provide you back a version that, to the extent it incorporates any of those requests. Which leads to the next question. I think I talked to you about both previously when you were here to visit the facilities. Certainly counsel and the defendant, though it is an administrative proceeding, have the right to be present. But when the questionnaires are administered, but I suggested to you that perhaps your time is better spent in reviewing the questionnaires than watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to counsel on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for one or not proposition.
Thank you, Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, very well. Is that accord, Ms. Taylor?
Yes, Your Honor.
All right, very well. So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms. The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
No, thank you.
We'll waive our presence for
All right.
that, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires, as I'm sure you're aware pursuant to Criminal Rule 23. Those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes. The copies you receive will be returned. And the defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see, so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the
Sure.
court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us. Just with the magnitude of the task, we'd like to have the assistance of our paralegals in organizing and reviewing.
Sure.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality, because it is part of what I'm giving the jurors on the instructions, is letting them know that there's very limited number of eyes that will review this, and that the public never will. So. The plan will be to try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer, right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat. Any questions about the juror questionnaire process?
Sir.
So the next topic I have is voir dire, more specifically. Traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to. But the idea is after that more group discussion, the individual or dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question.
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case specific information, the media items.
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual. So, you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views, it makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues where they may, simply give a view of capital punishment and that one that it's clear that they're not qualified either one side of the coin or the other. But if you want to deal more if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how the questioning will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendants' family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit, because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is. And I want to protect the jurors' privacy as much as possible in that regard. And so this does allow for a public access is the right, but also allows the court to tightly control that process. And then the individual voir dire will be counsel and the defendant only. And there'll be no stream.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them, will that be on them, or does this court use paddles so that their numbers can be held up when we want
They'll
to
have a
register?
laminated paper, like 8x10 paper that has cardstock laminated that has the number on it. And it'll be the scramble number, not their original reporting number. My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get to at least through 3 panel a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, let's say that number is 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then
That have been
exercise
passed for
peremptories.
cause, correct. So once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to rule, gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between. Any questions about that process? Okay. So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. It's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything. If you both pass on a round, or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that rule as you go in. After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20, will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can. If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to. I issued yesterday an order in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here, if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, if you intend to have staff stay at a hotel. Let us know where that's going to be. You will each be assigned a conference room outside the courtroom, and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials, and use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process or the jurors?
No, sir.
No questions, thank you.
So the trial itself, the plan is to go from Monday through Friday with the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that. And I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning. From 8:15 to 8:45, if there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this, this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I had talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are holidays for which there would be no court, with the exception that if we are sequestered, we may have trial, and we'll address that as we go. Because I can't send jurors home for the holiday, and so we might as well use the time. Any questions about that trial schedule? Okay. All right, in terms of special needs that you may have for trial, I'm assuming there's no need for us to have interpreters for any witnesses.
No, sir.
And then technology needs. be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology? In terms of what we provide, it will be a overhead, what we call the Elmo device, which is the device where you set a piece of paper down and it projects onto the screen. And then we have a HDMI link for your computer to present whatever you want to from your computer. That's it. That's our technology. So anything beyond that, you'll have to bring. All right. Let's talk about seating in the courtroom, counsel table, and the trial broadcast. Each side, I think when we toured the courtroom, each side will have two counsel table kind of put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members. The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? Well, how many seats are you requesting and how many seats do you need are two perhaps different issues. But in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you. For the state, likewise, 3 seats, 4 seats.
We should be able to make that work, Judge.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating. What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, excuse me, is for those that have reserved seating, in particular, the victims. And I should point out, I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media. But if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, I would like to know, for example, we're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and at which days you won't. That goes for both the victim's family and the defendant's family. Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later, to go over sort of what that process looks like, so so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, where, if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom ins and zoom outs and things of that nature. It'll be the static views.
Before the court goes further, when we're talking about the reserved seating for families in the courtroom, if we have some other members of Mr. Kohberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating's going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator and she'll see what she can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them as the media might try to talk to them
Sure.
a lot.
All right,
Thank you.
I don't have a problem with that. I'm assuming the victim witness coordinator will want to be there as well, so.
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrios' office to let her know.
Are you talking about one per family?
Hopefully not like that, but we're
Thank
gonna need to split at least, we're gonna need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are at a premium, but.
Yes, understood.
Right.
Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we mentioned this at least in passing in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that a public live stream where their images could be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be undesirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just want to give Your Honor a heads up.
Your Honor, this case is very high profile, and we've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. I did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face while they testify. And we may approach the court with a stipulation for certain numbers of them.
Well, my intent would be with respect to victims, and I've already indicated, I think the 2 roommates are victims. There is a compelling interest to protect them. And so just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I gotta see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else, you're going to have to really convince me because of the public's right. And their hesitancy can be overborne with a subpoena. And that's what subpoenas are for. So I'm probably disinclined to do that in general for other witnesses. As you can see, I'm even hesitating with people that may have a line of work that is undercover if they weren't undercover in this case. So other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Your Honor, I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group. And it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time might be different. And I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, that's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict may be reached in this case is for the public to have the ability to see the evidence. So I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
All right, any questions about either the seating or broadcasting besides what we've talked about?
No, sir.
All right, let's move to then opening statements. Let me start with what you've probably figured out by now. I am not tolerant of argument during opening statement. So if somebody is arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, in about an hour, you're going to hear me say, counsel, you've got 5 minutes left. Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. So courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in voir dire, I should mention as well. Make a request at the beginning of your opening to enter the well, and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off. Any questions about openings? All right. Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and I'll be back. All right.
All rise. Okay. Okay. I'm trying to figure out what the hell he's talking about. I don't understand if he's trying to say that they just like won't want to be in the courtroom. I guess it is what he's trying to say when it comes to Dylan and Bethany, that they might not want to be in the courtroom, but there's going to be 2 seats reserved anyway, which I sort of already understood. And I'm assuming that the 4 family members he's talking about would be Bryan's family, which would be mom, dad, and both sisters. Okay. So I guess what he means is they're going to show up, they're going to testify. It sounds like he's not wanting to turn off the cameras completely. It sounds like it's just going to be audio when it comes to Dylan and Bethany, if that's how it ends up being. I guess maybe that's not anything that they've fully decided on just yet. Right now it's just conversation, but you'd think they would already have all this damn stuff figured out. I found the no interpreters thing interesting because we were told that the Korean chick that had it for Bryan, like, apparently couldn't speak English very well. So maybe that's improved since it has been almost 3 years since the crime took place and they don't need an interpreter for her anymore. Or maybe it actually like wasn't that bad and she could speak English just fine and they're just being like really rude about how she talks. I don't know. I don't know. But this is just crazy. Okay. Let's see, what else did I have? I took like crap tons of Post-it notes because this is like the best way that I can keep. The freaking stuff about the covert police is freaking interesting. I know that. Oh, thank you for the gifted membership, Tara. And thank you guys. Let me just do it in my voice. Thank you guys that have gifted memberships. Thank you for the $10, T Hoppy. Thank you so much for being a member for 17 months. Thank you for being here for 3 months. Thank you for being here for 3 months. Thank you for being here. Thank you for the gifted memberships. Thank you for being here. Thank you for being here. And again, thank you for the gifted membership. I appreciate you guys so much. Okay, let me get this back off of here. Okay, where to go? The covert police. That's wild. That's wild because he's like, basically, I don't give a damn how far into their drug bust. I don't give a damn if they've been covert undercover for 10 years and are like literally chest deep into their freaking undercover journey. I will blow their cover on the stand right now because they weren't covert in this case, so it doesn't matter. That's what he's saying. That's what he's saying. So that's a little interesting because that's putting somebody's life in danger. But then again, why do we have undercover police officers that are even involved in this situation in the first place? That's just going to literally fuel like all of the rug stuff. You know what I mean? You know what I mean? So I don't know. I feel like if they are currently undercover in another case and you are putting their lives at risk, then that's not cute, literally at all. I'm actually kind of surprised he took that stance on that a little, because to me, yeah, that's sort of like saying, I don't care if they're not covert in this case and they're covert somewhere else. I will blow their cover and put their job at risk and make their complete mission be a complete waste of money and blah, 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 blah. That's what I just heard. And the Daybell situation, that's why I take notes, but I go back and Control F on the transcripts and then try to find where I have questions. So I could have sworn he just said he helped the jury selection situation in the Daybell case? Is that what the frick Hippler just said? Is that what he just freaking said? I didn't know that. Thank you for the gifted membership, Mikey. Well, that's because I'm half Cajun, and Cajuns speak like really, really fast whenever they're aggravated. And I'm really aggravated because there's a couple of things in here that are wild. Exactly. He'll put cops' lives at risk, but not put Dylan or Bethany on camera. I'm sorry. I'm sorry. Everyone and a mama and a mama's mama and their cousin knows what Bethany and Dylan look like. What? I don't understand that. We know what they look like. It's not like y'all are freaking going to be showing anybody their face for the freaking first time. That's not how this works. Literally at all. I'm wondering if the defense has always had 3 investigators or if that's new. The document that we had recently about people like in the courtroom for trial is that they wanted 2 investigators in the courtroom for trial. And now she's saying there's a 3rd one that is at least involved. I don't know if she said anything about them being there. Yeah. So I don't know. I mean, I'm sure they do. They have to submit more information when it comes to the alt perps. You'd think they would already have that. See, this is the kind of stuff that I get really freaking aggravated with. I don't really give a damn which side is being ignorant and stupid and lame and slow. You should have this. You should have this. You've been working this case now for 2.5 years. You've got literally everything that they've handed over to you. Plus you're doing your own investigations. Plus you have whatever Bethany has. And you've got these 3 investigators. Well, why did you not turn in all the information that was sufficient to prove your case whenever you handed it all over? Why is he having to say, hey, we need some more information? You need to give me something that's not going to be completely objected every single time something gets mentioned. Someone's going to object it in court. You've got to give me more. Why didn't they just do that to begin with? Why didn't Ann Taylor just turn in all the freaking information now? Why are we having to be told that now we're waiting because they didn't turn in everything? See, that's the part that's just ignorant. Like, y'all literally should have had this shit together already. I wrote the dates down for the no trial so far. 10/2 and 10/3, Hippler has previous commitments. 9/1 is a holiday. 10/13 and 11/11 are apparently also holidays. If the jury ends up being sequestered, which at this point in time they're not, then they'll continue on with court. But other than that, there just won't be. Witnesses. He said something about putting up witnesses, blah, 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 whatever. I wonder if since they're trying to, well, you know what? I don't even know if they've actually validated this. If Bryan's parents are called in as character witnesses or witnesses to the Amazon purchase, does that mean that they're counted as witnesses that the state would have to house? Because I know that Bloom Blum, whatever, said that Ann Taylor had put his parents or his family or had reserved them an Airbnb or something like that in his article. And of course, you know, he's full of shit half the time, most of the time, 99.999% of the time. But this makes me wonder if they can be paid for if they're considered witnesses. So I don't know. I find it hilarious that Xana was like, we shouldn't be calling Anna Dollhouse because of what happened there. Honey, baby, nothing happened there. What happened happened in a house that y'all destroyed. So I'll call whatever the frick I want a dollhouse. Y'all took away the real house. Shut up, sit down. That's stupid. Let's see. Monday through Friday, 8:45 to 3:30. And from 3:45 to 4:30, they're going to talk about whatever is happening the next day. I wrote down like a lot of shit. I think that's pretty much it. Yeah, they're going to take, like, what do they say? Between 50 and 55 jurors, like that first round. That's a lot. That's a lot. And of course, just like everything else, the jury questionnaires are private and confidential and blah, blah, blah. Like, we already know this. Oh, okay. For the alt perps, which we're going to end up going back through all of this stuff again whenever we do the live, like, review later. But anyway, for the alt perps, he wants all the additional information, meaning why is this admissible, and all the physical evidence by 523, because as he said, his verbiage was, it's fairly objectionable. Okay. He wants the state's response to whatever the information is on the alt perps by 6/6, and then there's probably going to be a sealed hearing because this part sealed itself on 6/18. So we'll see. Honey, baby, nothing happened there. It didn't. It makes me so mad because that's like where it really happened, and that's the place that should be being protected. And instead, they just got rid of it and they burned the remnants, and They literally made sure it was vaporized like back on the Star Trek show. Like it's ridiculous. Okay. I think that's it for right now. I'm gonna go get some more coffee. I don't know. They didn't say how long they were gonna be out. So that's beautiful. I don't know how long I have. I'm gonna go ahead and go make my coffee real quick. So I'm gonna get off of here. I'll be back, you guys.
All right. We are back on the record. I wanted to, I failed to, when I was talking about the trial schedule, one in the morning and one in the afternoon. Lunch will be 45 minutes. Food will be brought for the jurors. We've already talked with counsel about the fact that they can, if they like, elect to also receive the meals the jurors do. They will be charged for that, obviously, and we'll have to pay for that. But for convenience sake, keep things moving, be sure you let the trial court administrator, Sandra, you or Randy, let Sandra know about that. All right, moving on to witnesses. By 5 o'clock each day, you need to give notice to the other side, the witnesses that you will be calling that next day. If it's over a weekend, by noon on Saturday. The list should be a realistic one and not everybody on your witness list. And it should be tiered into two. One is the ones that you definitely are going to be getting to. And then if you have time left over, who you would take and in what order. I do like to use the time efficiently, so I don't generally grant the request with if we're normally stopping at 3:30 at 3:10 or so to say when you end a witness, well, can we just stop here? The answer is generally no. Let's use the 15-20 minutes that we have, because in a 3-month trial that adds up at the end of the day. So have enough witnesses ready to go to fill the time. And it's always good to have one or two who you always have at your side. So for example, if the state, a law enforcement officer, who's there, for example, you can call and put on something if worse comes to worse. But I want to make sure we use that time efficiently. With in addition to giving the list of witnesses you're going to call, you need to provide a list of exhibits you intend to introduce with that witness, short of obviously impeachment, so that the other side can look at those. That doesn't include exhibits that you would put in as part of redirect examination. So for example, the defense in the state's case cross-examines on some other exhibits that you didn't bring up, or there are exhibits that you didn't bring up that would explain what the defense brought up. You don't have to give notice of those exhibits. You don't have to anticipate that, in other words. Now, this is not a remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And I will figure out something to make sure that you do, although I don't expect it will be a problem. You should know what exhibits you're going to use, and there's no real secret here about what exhibits go with what witnesses. And I say that because there's always going to be leeway where you have an exhibit that you forgot you need to use, or a witness testifies in a way that you now need to use another exhibit. So, there's leeway there, but giving the other side a general idea of the key exhibits that will be used so that they can review those to prepare, I think is fair. The corollary to my use all the time that we have is don't filibuster. I will give an example that I have used, that I have violated my own rule in the past. When I was in your shoes, where I had a young associate handling a witness who the next witness was going to be the client, and we didn't want to get to him that day, and he kept turning around thinking he was done, and I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster. I've learned to come as a judge. You sometimes feel like your client is the jury in some ways, right? You want to make sure that that they are comfortable. You want to make sure they are treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, don't waste their time, either by having gaps that we can't fill or by filling it with stuff we don't need to use where we could be going to another witness. The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered? And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach. If it's specific to that, if it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say it. They'll get it. Just let them do their job. I'm assuming that there is, based on our prior motions, a agreement. Well, I'm assuming at least one of you would like to exclude witnesses pursuant to 615. Because if that's the case, then they will be excluded, generally speaking.
It was the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by the, or excused from it by the court. Or you can agree not to use 615.
I want to talk about experts, though.
Right.
Experts being allowed to view other expert testimony.
Correct. Yeah, experts are generally excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling, and crime victims are excluded from it.
I want some further clarification with our experts.
And I
know
think,
that
I think you guys agreed that your investigators would be excluded from it as well.
we did make that agreement. I think that may have even been in writing.
I'm sorry, I didn't mean to interrupt. I would just had that thought. And I didn't want to lose it.
So that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is, with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if they can't make it to Idaho?
Mr. Thompson? You have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to get an admonishment, acknowledgement from witnesses as they appear.
Bailiff, could you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. That's not the, I'm not wed to the exact wording. So if you have wording suggestions, I certainly will listen to them, but that is the gist, is that they will provide such an affidavit each as they come to testify. Any concern with that?
Not with the wording at the moment. A question of clarification, though. If the case should reach a phase 2, does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness
Only a phase 2.
and they attend phase 1. Is that what you're asking?
If they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
And I think that would support the need for them to be able to know it if the state's going to rely on things that.
Are you talking about experts?
Experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to any phase 2, the lack of them that apply to phase 2, and because the state's going to rely on what was in phase 1. So yes, experts and some potential lay witnesses as well.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of, to see if the state has a problem with that. Counsel who calls a witness, unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware? I'm going to, while we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines. So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. So that can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony, objection, overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That's it. If you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from council to the bench, but that's fine. As I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is as much as possible to have those discussions here at the bench. Now, if it's a very significant issue that requires much more leg room, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record, that is making a rebuttal. And at least until it goes over to State Street, I get the last word and not you. And so I don't generally afford that opportunity. So if after I rule and you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advance as possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Thank you.
While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that.
No objection.
Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
I assume you have replacements you have or will get to me for those.
And actually, we had a procedural question we were going to ask the clerk, but I'll ask your honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be prepared, you may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, it's kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome. If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Your Honor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
And if you don't let them know that, and well, either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable, because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them. And then I would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it and get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits?
No, sir.
Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity. Some of the stuff, key actual evidence items, whether that's DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that. So I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review?
Yes.
And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay, if you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Okay. And then I would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena, just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury, generally there's 3 ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other 2 approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing. Generally don't allow pre-admission because what I find is that I admit all these documents that then are never addressed during the course of the trial. And I don't want a bunch of exhibits to go back to the jury that they have no instructions on, that they've had no question and answer with a witness to explain what the relevance of those things are so that they can just go back and use to justify whatever position they want to have from them. I think that's dangerous. And so the process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You're going to use exhibit 6, witnesses on the stand, just say, Your Honor, I'd like to go over exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right. Exhibit 6 is admitted. And then we go from there. On voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant, right? So that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47, but they're separate exhibits so that the jury can keep those in mind, and we can keep track of those. It looks like from what I received, the state's using S dash number for its exhibits and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, so I like to say, the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay. I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here, or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab with the sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury. And so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, will probably be in a display case. If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted, I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored. Whether that's with a sister agency or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain. Depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial. All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in that. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes or something like that when you have 30 minutes left, so just let me know in advance. All right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase, as the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay, well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if I have stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right, anything else before I move on to jury instructions?
Not from us, Your Honor. Thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. from the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
Jury instructions, I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's a instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together. So take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think it does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-approve, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly probably the next day, unless it's, Friday morning when we get that, then we may not start till Monday or something, but given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase, and there is a finding of aggravating circumstances, or then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay. Let the court reporter know whether you're going to want routinely daily transcripts or not. You don't have to tell her now, but
Daily versus real time.
so there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
For separate fees if I want both.
Correct.
Yeah, make that decision.
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Thank you.
And we obviously need to know, particularly about the real time in advance, so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior.
It'll be
to
part
these
of
two.
the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you can think of? All right. That's my list of stuff, and I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss. And so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors. So we'll do that in the closed session. But anything else in the public session we need to talk about?
I don't believe so, Your Honor. Thank you.
Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
Spare that we could have, Your Honor. That
Sure.
Oh, it's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I'm going to be entering an order requiring the retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side. to preserve records. All right. All right. Anything else? All right. Thank you. Why don't we come back in about an hour? All right.
Okay. Okay. Yeah, that grant immunity part, I'm not sure what the freaking shit. I don't know what that's talking about. I'm going to have to go back and listen to that over again because I literally almost typed in, what is this about? I'm not understanding. And then it did this. Okay. So they're going to be gone for an hour. Or at least I heard it at this point. That last part is really confusing. It says during the closed session, which is the reason why they were a half hour late. They weren't technically late. They were just, not public. They could have warned us, but whatever. He filed something for the state to retain records, and now he wants to extend it for the defense to be able to retain records. And he's talking about gag order violations, bringing in a special prosecutor. So does that mean that they have a list of the gag order violations? And could that be the discussion because of the stuff with Dateline, I wonder? And I wonder, what this immunity thing is for. Immunity to the people that freaking leak shit in a gag order? Is that what he's talking about? That portion is really confusing. So I'm going to be definitely listening to it again, and we'll talk about that in the live tonight. I'm not going to show the entire thing all over again because it's hella freaking long for no reason. So I'm going to just go through my notes again whenever I get off work later and organize everything and just take certain portions that we need to go over. And that one's definitely going to be one of them because I don't know what the frick he just said. That's wild. Okay. Let's see. What is he talking about when it comes to a weapon? That's the part I don't really quite understand. The only thing that makes any sense is if they did find a weapon of some sort and they just haven't said anything yet, which is highly unlikely, honestly, let's be so serious. Or if they're using, they went on Amazon and bought the exact same kind that matches the sheath that was found. And now they're just going to have a duplicate sitting in there in a display case as an example because of the sheath being found. But they need to come out and admit if that was even used, based on the wounds or not. They can't just keep on that. That's absolutely wild. This is the most ridiculous thing I think I've ever heard in my life. This is nothing but a bunch of instructions. He's speaking to them like they're freaking little babies. They've never done anything before. They've literally done absolutely nothing important besides being instructed on how to do something that they've all done over a dozen times and should know exactly what to do. Yeah, the arguing about who's ever is blocked on wherever, it needs to chill because it's been already 25,000 comments on it, and it just, yeah. Anyway, back to the subject at hand. The exhibit situation being taken back is a little bit confusing because I'm not understanding if he's trying to say that he's trying to take the grand jury exhibits away from the courthouse just for them to be used at trial, or if these exhibits are going to be taken so that replicas can be used at trial. That's another thing I'm going to have to go and listen to because that's a little odd. If they're the same thing and they're already at the courthouse, why not just leave them the frick there? Because if you're going to use them, you know what? We're just going to figure that out later. There are still going back and forth with a couple of things that have been claimed by the state to be authentic. There was a list, some new, some missing authentication. I can't even freaking say the word. Some missing certificates were finally turned in. But Anne has issues with them and they're still going back and forth. So he wants to get that out the way now so that there's not any objections and a bunch of back and forth when it comes to the people getting on the stand to say that something's authentic or not, which is, legit. If you don't know if it's authentic or not, it shouldn't even be being discussed at trial. So if we're having to argue with that at trial, we're a little bit too late and a little bit backwards. Let's see. The whole thing about the penalty phase situation, all that stuff having to be discussed now is the reason why Ann Taylor's team wanted them to separate this into 3 pieces instead of 2, so that we weren't having to discuss stuff that would be coming up if there is a penalty phase before we even know what the verdict is going to be. So that does make things pretty stupid, especially whenever he sits there and tries to act like he doesn't know how the human brain works, whenever he says that in one portion of the jury instructions, because it's a capital case, that they need to be told to be prepared to vote on the death penalty. But then they're also told that whenever they're thinking about innocence or guilt, not to think about the fact that if he's guilty, they're going to have to put him to death. I'm sorry. I'm sorry. That's not how the human brain works. We already know. What's the phrase we use? You can't unring the bell. Like, come on, broski. He's instructing them like they've never done this before, while he is actually saying things that make me feel like he just doesn't really understand a lot of things. But then again, that whole, he helped do something with the Daybell or whatever jury thing was interesting as shit too, because I didn't know that. So I'm going to be looking that up a little bit more. Let's see. I'm so pissed. I'm so pissed. And I have every right to be pissed. And I'm going to be pissed for about 2 minutes, and then I'm going to go over it. Most of you guys know that I have been dealing, well, I'm not dealing with it anymore, but dealt with a DV situation. And for my own protection, because of everything this man has done, threatened to do, track my car, all kinds of crazy stuff, take our lives, all these things, me and my children had the discussion and said, we need to be able to remote in to testify, because it's not safe for us to be so far away from where we live now, to be over there in an unsafe environment that we have no one around. It's literally just us. And, he's been out running free and could easily do something stupid or have somebody ready to do something stupid the second I walk up to the court steps. And they wouldn't allow me to do that. But they're going to allow some of these witnesses in this quadruple homicide trial to remote in. Do you know how freaking much of a slap in the face that is? That is so disgusting to me. Like, this is way more important than the situation that I was dealing with. And they're going to allow them to remote in instead of be there in person. But I couldn't do that for me and my children's own safety. That is absolutely freaking bullshit. Granted, it's 2 different states, but whatever. The rules should be the same everywhere. And that just severely freaking pissed me off. Okay, rant over. Let's see. See, and this is the whole thing with like the second phase of like the penalty phase even being like brought up, I guess, because they're having problems now with allowing people that might or might not be involved with the penalty phase having some sort of involvement or even getting to watch this portion of it. And to me, that's just absolutely stupid. If it's streamed publicly, then, you really just can't stop people that aren't here from looking at it. They're going to freaking look at it. I have a question. I wonder if they've ever put Murphy in a room with Bryan. Like, did they ever call Jack and be like, hey, broski, bring that dog down here. I want him to sniff the defendant. Did they ever try to like do any of that and see how Murphy was going to react to Bryan? Because I'm sorry, if the dog just ran up to Bryan wagging his freaking tail, or allowed Bryan to pet him and didn't growl at him or feel scared or try to run and hide, I think that pretty much will give you your freaking answer, because that scent would be something that would trigger in that dog's brain. And there's no ifs, ands, or buts about that. That's just true. Let's see. He's a bully. He is a ginormous ass bully. Every single time he's like, if you don't do it like this and you do it some other way, then you're not going to like what I do about it. Shut up. He's absolutely just a rude little shithead. Y'all all were like commenting on a niece being talked about. I have it written down, but I don't know if that was actually said, if it was misheard, but several of you guys wrote it in the comments. So I'll be going back and looking back at that. I honestly think that's it. Yeah, because I had 10 post-it notes before the last break, and that was 11 through 15. Okay, yeah. I know, right? Brilliant I did about Murphy. I don't know why maybe they did. Wouldn't it be like really screwed up if they did and it's on camera and like they were kosher and there was no reaction? And they like know that? I mean, I'm just saying they probably should have tried that. Anytime there's an animal, like a dog at all during a crime, they should probably let the animal respond to the defendant. Okay, I am going to get more coffee, probably grab something to eat out the kitchen because I work from home, so I can just do whatever I want when I want, eat whatever I want, do whatever I want. So that's what I'm gonna go do. It's been like 10 minutes I've been running my mouth. They are probably gonna come back at it's 1:19 my time Central. So I'm going to assume that they're going to be back a little after 2-ish my time. So I'm going to get off of here right now, keep this full screen. I'll pop into chat whenever I get back to my desk. I know they said that something was going to be closed, but it's not off yet. I know what other people are doing, but I'm staying right here until probably 2:30-ish, 2:45-ish. You don't have to hang around, but I'm staying here just in case they come back on and see if there's anything else that needs to be addressed before they go to closed, because right now they're technically on their lunch break. It's only been 7-8 minutes past the 1 hour mark from the time stamp that I have from, whatever. So we're waiting. I'm waiting until 2:45. And if nothing by 2:45, then I'm going to shut it down because I got things to do with my life. And so do you guys, but I'm going to keep it on my end in case something happens. And if something does happen and come back up, which I honestly do doubt, I'll come back on. But I'm staying here for at least another 30 minutes, just FYI. Okay, you guys, I think we're done. I have, how many? Oh boy. What number is that? Okay, that's 11, 12. Post-its. And no, nobody say, somebody buy Jules a notebook. I love my post-it notes. Okay, it actually helps my brain. 15 post-its, information that we're going to go over tonight. I kept it open because I wasn't sure if they were going to come back for anything at all. I don't know if they were going to try to come back and say anything, ask if there was anything else publicly that needed to be addressed or whatever. That's why I left it open for an extra 30 minutes. But they are supposed to be discussing other things. I did find it really, really interesting. When do we get to find out what's on those post-its? Tonight, whenever we go do the live review. I'm not going to do my email. It's in the whatchamadoodler. I'll type it in here. It's on the main page. Whenever you click more info on my whatchamadoodle homepage thing. We're not. Is my keyboard battery dying? What is happening? My keyboard battery is dying. So it's not letting me type. Okay. Tonight, I'm not going to go over the entire hearing. I'm going to pick the pieces out that I know that we need to re-listen to. But everything else, I'm going to go through in chronological order. What they started with, because I have everything from the jury cues, the dollhouse, all the perp information and the questionnaires. I took little bitty notes on everything, but yeah. Tonight, probably 7:30 to 8:15. I'll start around there sometime. Okay, hold on. I don't even know my freaking email address. All right, it should show up there. Yeah, there's so much to discuss, but not really so much to discuss at the same time. I mean, I kind of figured they weren't just going to come out and be these are the people that we think are responsible right here in open court. That would be really stupid, honestly. But I am really disappointed in the fact that Ann Taylor didn't do better. Ann Taylor is not a very good attorney. I'm sorry. I know a lot of people like her, but she's just not. She's not a very good attorney. And it's kind of sad because she has that entire team. And they've been talking about, trying to prove that Bryan is innocent or whatever they're trying to do. And you turn in the alt perp stuff and there's no substantial physical evidence attached to it. There's no explanations for anything. It's just all of your theories. No proofs. You're wasting time. Why would you not put the proof with it? What's the point in trying to say that the PCA is completely stupid and pointless because there's nothing to back it up that's even real? But then when it comes to the alt perp information, you basically just did the exact same bag of shit bullshit. I don't know. I just think it's dumb. But yeah, the special prosecutor needed for the gag order violations is interesting. Because the Dateline thing, no, they didn't say that specifically. That's just the huge assumption because the Dateline thing came out. And, Keith Morrison said, this is the stuff from the state's evidence. This came from the FBI. This is the stuff the state had against Bryan Kohberger. Whatever the frick he's saying. Oh, that sounded more like Nancy Grace and Keith Morrison. Anyway, he's the one who came out saying that it was from official sources, official sources, official sources. So, you know, they're going to have to deal with something. But it was interesting that there's all of a sudden like an extension to things, because I guess maybe originally they thought that the state might have been the one to violate the gag order, because he said that the original record for retention for this was only for the state, but that as of this hearing, he's filing an extension to expand it over to the defense as well. That's what they were talking about this morning, which is why they were late opening up. But again, people are just assuming it's because of the Dateline thing, because of the timing, because of the events, and the fact that why are we talking about that right now if it's not about Dateline? So we'll see if anything even comes of it. Some clarification would be nice. I don't understand why, considering that every single thing is out there already, that Dateline is apparently allowing out there that was leaked to them. Why can't we discuss that in public? Why can't we have an open public session about the bullshit? If the public has already had to witness it, then why can't we witness the people that are responsible for it? I don't really quite. Maybe they will at the end of the day. Let us know about that situation, but I highly doubt it. But I'm going to go ahead and get off of here for now. Hitler's voice is in my brain and I need it to remove itself. All he did was talk today and talk. I don't understand again why he's talking to them like they're kindergartners, like they've never done this before, like they have no idea what to do. It was very child teacher-ish to me. I don't know. I didn't like it very much at all. But yeah, I'm going to go ahead and close this thing out, guys. Y'all have a great rest of your day. Again, sometime between 7:30 and 8:15, I'll be live tonight to just go through the highlights with a couple of the little clips of things that we need to try to get some clarifications and stuff on. In the comments after this, post in a second whenever I close this off, if there's any questions or anything specific that you guys want me to go back over. Again, wait till this processes. It only takes like a minute or so after I close the live, and go in the comments after it posts to YouTube and leave me that information in the comments so I can make sure that I go back in and get the things that some of you guys have questions about. Thanks for watching the trial with me. Not the trial. Oh, we're not there yet. We're not there yet. Thanks for watching the hearing with me. Thank you for the gifted memberships, the super chats, the super stickers, anyone who came in and ordered and got a membership for themselves. All of you guys being here watching this with me, thank you so much for spending your time here. Let me go ahead and close this little thing out like I normally have to. Please do not forget to leave a like on your way out and subscribe to the channel if you are not subscribed already. All right, now I'm going to set the ending. You have a great night. See y'all.